Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-decision episode of SCOTUScast. I'm your host, Spencer Carr. On April 22, 2021, the Supreme Court decided Carr v. Saul. The issue is whether a claimant seeking disability benefits under the Social Security Act forfeits an Appointments Clause challenge to the appointment of an administrative law judge by failing to present that challenge during administrative proceedings. In a 9-0 opinion authored by Justice Sotomayor, the court reversed the ruling of the United States Court of Appeals for the 10th Circuit and remanded the case. The Supreme Court held, quote, "Principles of issue exhaustion do not require Social Security disability claimants to argue at the agency level that the administrative law judges hearing their disability claims were unconstitutionally appointed," end quote. Justice Thomas filed an opinion concurring in part and concurring in the judgment, in which Justices Gorsuch and Barrett joined. Justice Breyer filed an opinion concurring in part and concurring in the judgment. Thomas Berry, research fellow at the Robert A. Levy Center for Constitutional Studies of Cato Institute and managing editor of the Cato Supreme Court Review, joins us today to discuss this decision and its implications.
I'll start by giving a little background on the type of administrative hearing and administrative judges at issue in this case, because that background is really kind of necessary for understanding the competing issues at play and the various options the court had for either a wide or a narrow holding. So this case is about Social Security Administration administrative law judges. SSA, or the Social Security Administration, is a sprawling agency that's notable, among other things, for having by far the largest cohort of administrative law judges of any agency in the federal government. In fact, out of roughly 1,900 total administrative law judges, or ALJs, about 1,600 are in the Social Security Administration alone. The remaining agencies have roughly 300 combined. So coming before a Social Security ALJ is a necessary stage in the process for anyone who's dissatisfied with the outcome of a claim for Social Security disability benefits. The law requires claimants to go before an ALJ before they can take their objections to federal court. Now, because there are so many disputes between claimants and the Social Security Administration, these hearings are much faster and far more casual than anything that might come to mind when you imagine a typical courtroom setting. Most notably, it's not a situation where the claimant or the claimant's lawyer, they're allowed to have one but not required, argues for a claim and then a government lawyer argues against the claim in the typical adversarial process. Instead, the hearing is modeled on the so-called inquisitorial process, where the Social Security judge simply asks the claimant questions, tries to get a handle on what the issues are, ascertain what the strongest and weakest points in the case are, and then issues a decision. As the Social Security Administration itself puts it in a guide to the process, quote, "Under our inquisitorial hearings process, an ALJ fulfills a role that requires him or her to act as a neutral decision maker and to develop the facts for and against a benefit claim." So you can think of the Social Security ALJ as something of a hybrid, acting a bit as objective interviewer, a bit as claimant advocate, a bit as government advocate, and then finally as judge. Once again, the SSA's own words, the judge wears, quote, 3 hats, quote, helping the claimant to develop facts and evidence, helping the government investigate the claim, and issuing an independent decision, end quote. So while claimants can have a lawyer present in these hearings, it's not really designed for them to feel like they need one to navigate the process. Now, once the ALJ issues a decision after such a hearing, if the claimant is still dissatisfied, the claimant then has the option to petition another round of administrative review within the agency, and that's called the Appeals Council. Whether they appeal to the Appeals Council or not, once the administrative decision is final, only then is the claimant allowed to bring their claim to federal court and then up through the federal court system. So with that background on kind of what the system is that we're talking about and what's lying behind this case, here's the sequence of events that actually set the dispute of this case in motion. In 2018, the Supreme Court decided a constitutional case called Lucia versus SEC. That case was about administrative law judges in the Securities and Exchange Administration and whether they had been appointed as the Constitution requires. The Constitution has a clause called the Appointments Clause that requires all, quote, officers of the United States be appointed by either the president, a department head, or a court. But the Constitution doesn't define what makes someone an officer of the United States. So ever since that clause was written, the Supreme Court has had to draw the line on which federal government employees fall into the category of officers. The details of Lucia aren't important here, but suffice it to say that in Lucia, the court held SEC ALJs have enough authority that they do qualify as officers, meaning they need to be hired by someone in those high-level categories. Now, why was that ruling significant to the Social Security Administration? Because those 1,600 ALJs I mentioned in SSA have very similar powers to the ALJs in the SEC that were at issue in Lucia. In other words, the court's holding in Lucia almost surely meant that Social Security ALJs are also officers. But unfortunately, for the Social Security Administration at least, it had not appointed its ALJs in one of the three ways required for officers at the time Lucia was decided. It only did so belatedly after the decision came down in July 2018. That's when the acting Social Security Administrator announced that she was, quote, ratifying all of the ALJ's appointments. Effectively, she was saying that she was rehiring them all herself in her capacity as the head of a department, one of the types of hirers that the Constitution allows. So that may have solved the problem for future cases after Summer 18, but the cases decided by those SSA ALJs before July 2018 remained in legal jeopardy. The Supreme Court has held repeatedly Appointments Clause violations are structural, meaning you don't have to show that your particular judge was biased or incompetent on account of being not hired by the right person. Rather, the Appointments Clause is about more background principles of accountability, the right to be before someone that the department head has taken responsibility for hiring. So when there's an Appointments Clause violation, that violation by itself is enough to entitle someone to a new hearing before a properly appointed judge. And that's what many of the claimants who had their cases decided by these ALJs before summer 2018 asked for when they got to federal court. But that's when they ran into the obstacle that became the crux of this case, and that's a doctrine called administrative issue exhaustion. Now, the idea of issue exhaustion in general is familiar to any lawyers who litigate in the federal system. It's Appellate Law 101. You can't raise new claims on appeal that you didn't raise in district court. But administrative issue exhaustion is a trickier question. Can you raise new claims in federal district court that you didn't raise in the administrative hearing before the ALJs? Now, for many agencies, there are statutes or regulations that spell this rule out in detail, and when they do, courts simply follow them. But not so for the Social Security Administration. Its laws and regulations are silent on the issue, which means it's up to federal courts to decide for themselves whether to impose such an exhaustion rule. Now, issue exhaustion in the case of the Social Security Administration has come up once before at the Supreme Court in a 2000 case called Sims versus Apfel. It was about that discretionary appeals court I mentioned, the Appeals Council. Now, the Supreme Court in that case confronted the question whether there's issue exhaustion for issues a claimant doesn't raise in the Appeals Council, but then wants to raise in federal court. Four-justice plurality, written by Justice Thomas, would have had a broad holding that essentially any hearing with an inquisitorial rather than adversarial approach is not fit for issue exhaustion because essentially you don't have the same development of facts and development of issues that you have in the typical federal district court process. And so the typical justification for requiring raising all issues at that stage doesn't apply. But that was not the majority holding because Justice O'Connor joined the judgment on a much narrower ground. She looked specifically at the particular forms dealing with the Appeals Council and decided that those did not give enough notice to claimants that they might raise an issue, they might forfeit an issue if they didn't raise it. And so she held that it would have been unfair to impose issue exhaustion in that particular case. So the fact that Justice O'Connor did not join the plurality's broader reasoning was very consequential, because it essentially left the broader principle unsettled of when is there and when is there not issue exhaustion in the Social Security context, specifically for that first stage, for the ALJ hearing itself. And so courts split on the question of whether issue exhaustion applied to appointments clause claims. In nearly every case, a claimant did not raise the appointments clause in that informal non-adversarial hearing that I described, and that's understandable. If they usually don't have a lawyer with them, let alone a constitutional lawyer. And this issue of the appointments clause really didn't get attention until Lucia was decided. Obviously, some lawyers who are closely following the case may have had it on their radar, but the general Social Security claimants certainly would not have. And so those are the type of people at issue here, people who did not raise the appointments clause in their ALJ hearing, typically before July 2018, but then wanted to raise the appointments clause once they got to federal district court after July 2018. And some circuits held that they could, but two circuits, the 8th and 10th, held that they could not. They essentially started with a background presumption that issue exhaustion is the default rule unless there is a sufficient justification to depart from that default rule. And looking narrowly at Justice O'Connor's decisive fifth vote, they held that it was so specific to the Appeals Council that it really couldn't be extended to the ALJ hearing itself. And so they held that there is still issue exhaustion for the ALJ hearing and essentially any issue raised at the ALJ hearing. The Supreme Court, so both the 8th and 10th Circuit, on the basis of that reasoning, denied claimants the right to raise an appointments clause claim, essentially denying them the right to even have their constitutional argument heard and have the chance to get a new hearing before a properly appointed judge. The Supreme Court granted cert on the issue, and that's how it got to the Supreme Court in that posture on a review of the 8th and 10th Circuit denial of review, and those two cases were consolidated. Now, once it got to the Supreme Court, the court really had a range of options for its holding from big to narrow. At the biggest end, but perhaps the most unlikely end, it could have simply established a bright line rule that Social Security ALJ hearings are so non-adversarial that there's no issue exhaustion for any type of issue, even one that the ALJ potentially could have ruled on. That would essentially be the four-justice holding that Justice Thomas wanted back in Sims versus Apfel, finally getting a majority. A little bit narrower, but still more in the nature of a bright line rule, the court might have said there's no issue exhaustion for any pure question of law, or maybe a still narrower category, like there's no issue exhaustion for any issue of constitutional law. And those were all, I would say before the decision came down, those were seen as the most likely outcomes because they were all that was really necessary to decide this case, since all of these claims were issues of constitutional law. And also they're really outside the wheelhouse of Social Security ALJs. They're not trained to decide constitutional issues. And in fact, they had been specifically directed by leadership not to address an appointments clause claim if it were raised. And so recently, this month, the court came out with its opinion in Carr versus Saul. And in fact, the court didn't choose any of those options. It took the narrowest option available to decide the particular case. The court expressly, it ruled 9-0 in favor of the claimants. It ruled that there was no issue exhaustion in their case and they could raise the appointments clause claim. The majority opinion was by Justice Sotomayor. And there were, in addition, two concurrences joining on the judgment by Justice Thomas and Justice Breyer. And the majority opinion expressly limited its holding to, quote, the specific context of petitioner's appointments clause challenges, end quote, holding that in that context, the scales tipped decidedly against imposing an issue exhaustion requirement. And to make clear the narrowness of the holding, the court added a footnote saying, quote, outside the context of appointments clause challenges, such as in the sphere of routine objections to individual benefits determinations, the scales might tip differently. In other words, the court is not going to reach that question. But if we look at the factors that the court used in deciding why the scales tipped the way they did, one at least strongly suggests that the court would have reached the same outcome for any constitutional claim, not just the appointments clause claim. The first factor the court mentioned was that agency adjudications are, quote, generally ill-suited to address structural constitutional challenges, end quote, which usually fall outside the adjudicator's area of technical expertise. And the second factor that the court mentioned was futility. As the court noted, quote, it makes little sense to require litigants to present claims to adjudicators who are powerless to grant the relief requested. And that was the case here. As the court noted, the SSA had directed ALJs to acknowledge appointments clause objections and then say they did not have the authority to rule on them. Now, what was the government's primary argument here that did not get a single vote? Essentially, it was a challenge to the notion that it really was futile. And the government had an interesting argument that even though it might have been individually futile, it was not necessarily collectively futile, because if enough people had raised appointments clause claims in front of the ALJs, the agency itself might have took notice of the problem earlier, and it might have done what it belatedly did in July 2018 earlier. In other words, it might have ratified them earlier. And the government had one case on its side called L.A. Tucker Truck Lines from 1952, which had seemed to endorse that type of theory. But the court took a relatively narrow approach to distinguishing this case from that 1952 one. The court pointed out that in the 1952 case, the adjudicative body at issue was itself the body with the power to change the policy. In other words, the government's theory in this case required one more hypothetical and uncertain step of information sharing. For repeated arguments to ALJs to cause a change in appointment policies, the ALJs would have had to communicate to the commissioner that they're hearing these repeated pleas of unconstitutionality, and then the commissioner would have had to act on the basis of that information. As the court put it in this case, quote, the SSA's administrative review scheme at no point afforded petitioners access to the commissioner, the one person who could remedy their appointments clause challenges, end quote. Now, that was the majority opinion essentially combined all of these factors and didn't say any one was decisive. It looked at non-adversariality, it looked at the futility, and it looked at the nature of the claim and the fact that constitutional claims are outside the wheelhouse of lower courts. But it didn't establish one bright line rule. Who had a concurring opinion, once again, stressing non-adversariality and asking for a bright line rule? Once again, Justice Thomas. So in some ways, this was a case of the more things changed, the more they stayed the same. The three justices who joined Justice Thomas's plurality opinion 21 years ago in Sims have all since left the court, but Thomas picked up two new acolytes for his position, Justice Gorsuch and Justice Barrett. So Justice Thomas has essentially come close but no cigar twice, 21 years apart, for a bright line rule that all inquisitorial hearings are so non-adversarial that there should be no issue exhaustion for any issue in them. So Justice Thomas, in his concurrence, said that he would have simply stopped the analysis at the inquisitorial nature of the hearing and not relied in addition on the fact that it was a constitutional claim and on the fact that the ALJs were instructed not to rule on it. And then in addition, we have an opinion concurring in the judgment by Justice Breyer, who essentially is the flip side of Justice Thomas. And Justice Breyer had been the dissenting judge in Sims versus Apfel. So the two justices who remain from the year 2000 essentially pick up their debate right where they left off 21 years apart. Whereas Justice Thomas argued that the inquisitorial nature alone should be sufficient for no issue exhaustion, Justice Breyer preferred a rule that issue exhaustion is the presumption, but that futility in this particular case tipped the scales against that presumption. So what is the implication for the future of this case? Well, we know in the short term that these particular claimants now have the right to raise their appointments clause challenge, and they're very likely to win. In fact, the fact that the Social Security Administration ratified the appointments of these judges seems to be a concession that they were in fact unconstitutional, although they have not formally conceded that point. How many people does this affect? During the oral argument, the estimate was it's in the hundreds, not the thousands, because of course there is still waiver for federal court. So some people, if their cases were too long ago, they may have gotten to federal court and not raised the appointments clause claim. And typical notions of waiver still apply there. So this is a kind of small subset of people who happen to fall in that timeline where the ALJ hearing was before 2018, but the district court hearing was shortly after 2018. So they're all likely to get new hearings eventually. They're all likely to get new hearings, not just before a properly appointed judge, but a different one than the one who decided their case. The Supreme Court said in Lucia that you have to assume the person who decided their case may have prejudged it, understandably. And so the best way to avoid any lingering error is to simply give them a fresh start with a new judge. Now, here's an additional area where the theorizing might have an effect. And this is something that lawyers will probably look at creatively in reading this opinion. And that's forfeiture in the realm of structural objections to rulemaking. So I've been involved in some cases that have raised appointments clause challenges to rulemaking, and the government has attempted to argue in some of them that an appointments clause claim against a rulemaker can't be made in federal court unless the challenge raised that objection during the notice and comment period. So the fact that the court emphasized here both futility and lack of capacity is going to be very relevant to those types of arguments later on, because you can make essentially similar arguments that agencies, when they're looking at comments to a rule, they're really just looking for comments about the policies behind the rule, pros and cons, cost-benefit analysis. They're not really in a position to consider whether it violates some structural constitutional principle. And so in the same way that futility and lack of capacity to rule on constitutional issues was important here, it probably means that doctrine of forfeiture is unlikely to succeed on the government side in the rulemaking context as well. How will this apply to other agencies? Again, it's not entirely clear. The Social Security Administration is kind of a unique animal. This was also brought up in oral argument, and the lawyer for the claimants said that probably the other two most non-adversarial agencies are the Veterans Administration and the Railroad Retirement Board, not exactly of the same size or scope as the Social Security Administration, and both of those have rules set out. So the Social Security Administration really is somewhat unique in the fact that it's so large, so non-adversarial, and for some reason, even in the 21 years since Sims v. Apfel, has declined to have any rules or statutes really giving guidance on this issue. So what continues to be the biggest unanswered question in the wake of this is about Social Security itself, and it's whether there's a bright line rule for no waiver for any type of claim. But the fact that Justice Thomas's opinion still only mustered 3 votes rather than 5 makes me think that in future cases, the court is more likely than not to accept issue exhaustion for issues that are in the wheelhouse of ALJs, the typical sort of factual claims or legal claims about whether a disability was properly considered or not. But if there are any future structural constitutional issues, those are very much likely not to be subject to issue exhaustion.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.